personally in favour of public justice. I don't think that it should be made private, but at the same time, I think that there needs to be a certain treatment of these matters in a very serious manner that doesn't prejudice the outcomes of these cases or politicise them. I think that the question of corruption and the question of unethical behaviour or public misconduct while in office should be a question of fact. Police derive their powers when exercising authority in relation to this COVID-19 lockdown. So they cannot just verbally or on that sort of impromptu basis ask you to produce evidence of your exempt status or of your identification. But when a person has asserted that they have a medical or a psychological condition, the police officers should be satisfied by that according to the law.
Good afternoon. Welcome to Macquarie University Liberal Club's Sunday Sessions podcast, live from the Facebook main page. My name is Andrew Kremen, and joining me as co-host while Rory is out campaigning is Luke Stewart. Luke, good to have you on.
Thank you. How are you?
Very good. I'm very good. It's been nearly a month since Gladys Berejiklian resigned as Premier of New South Wales. Her secret relationship with Daryl Maguire landing her in an investigation for corruption. What is going on with the case? What are the scope of ICAC's powers? Joining us today is Cameron Shamsabad, solicitor at Legal Bit Lawyers, a regular on Rebel News, and editor-in-chief of the Australian Constitutional Law Journal, and host of the Surviving Constitutional Law podcast. Cameron, welcome back.
Thank you, Andrew. I'm very glad to be back. Whenever you say it like that, it sounds like I do quite a lot of constitutional law.
You do an impressive amount of content, that's to be sure.
I'm doing my very, very best to try and keep up. But as you can imagine, and as this ICAC situation has shown, the flow of public events and of current affairs is usually too much for any one person to keep up with. Nonetheless, I'm going to do my very best today in obviously covering the topic according to the questions obviously that you have and maybe some that the audience have as well.
Well, thank you for that. As always, you can ask your questions to Cameron in the comments section, and we will try and get to as many of them as we possibly can. First, talk to us about ICAC and about how it was founded.
So ICAC is a body basically that is essentially an investigative tribunal kind of commission, independent commission against corruption. It was established in the 1980s, in 1988 by the Liberal government of Nick Greiner. And it was established on the back of essentially what was a very corrupt period of Australian history in the 1980s, where all around the country, not just in New South Wales, governments were being effectively called out on multiple levels, whether it be in the bureaucracy or the police or even the ministerial ranks, for not only promoting but harbouring and obfuscating corrupt behaviour within the ranks. In particular, the Greiner government ran in the 1988 election on the platform, partly obviously, that it would establish this independent commission against corruption, particularly in light of the Labor government of Neville Wran and Barry Unsworth, which essentially had a number of elements to it that were corrupt or believed to be corrupt, and it was quite openly acknowledged that they did actually not treat that very well. And to highlight that, actually, Bob Carr, another former Labor Premier, obviously took upon review Wran's handling of corruption as a negative exemplar within Australian history. And I've got actually a quote here. He said, "I had never seen Neville Wran's premiership tainted and compromised on probity by..." He said, "I had seen Neville Wran's premiership tainted and compromised on probity by three distinct errors. One, the elevation of a corrupt cop as assistant commissioner. Two, the extension of the term of a corrupt chief stipendiary magistrate, Murray Farquhar. Three, being too slow to shake out police corruption." And he said, "Almost every week I was to watch him struggle to ward off allegations that his administration was tainted by a laxness towards corruption." So in light of that, Nick Greiner's government essentially came to power on the basis that if there's corruption, we're not going to be looking for it. There's going to be a separate independent body, essentially, that is going to be investigating and keeping an eye on these matters throughout the government bureaucracy in New South Wales, all the way up to the ministership, keeping an eye to make sure that the deals that are being done are not dodgy, that no one's getting any, unethical benefits from their public office, and essentially to cover off on all of those things. So the organisation was founded specifically to root out corruption and to ensure the integrity of public office holders. And they don't just sit in the New South Wales government ranks. It also includes local as well as state government bureaucracy. It extends to parliamentarians, local councillors, ministers of the executive, obviously, which is why we're discussing it today, public servants generally, and even staff at some of these state-owned corporations. So you see that, for example, with the Railcorp investigations that happened in the early 2000s or mid 2000s and stuff like that, including potentially even some universities that are state-owned or have state-backed, leaderships or tenures. So that was the basis. Now, the only exception that I've found to that is the New South Wales Police, which does have its own specialised Police Integrity Commission to deal with corruption in a sort of internal fashion. But that reform happened sometime later. So the commission was started in 1988. So far as I've been able to find, the police started dealing with their own corruption internally around 1996. But with that said, Section, I believe, 13 of the ICAC Act does require that the police commissioner, if he's aware of any sort of corrupt dealings within the public administration, to report that to ICAC as well. So the police do still have obligations under the ICAC Act as well.
Who are some of the big names who've been previously caught by ICAC for corruption?
Sure. Well, the way I talk about it is, if I can come back to that question, I'll add just a little bit on the structure of ICAC, because that gives us a sort of understanding on how the process works. And then I'll mention some of those characters that have been implicated since it started. So the first thing I'll mention is that it's got a fairly unique character. Unlike the New South Wales Police, for example, the ICAC does not really fit rigidly into the executive arm of government. It's not an investigative body that is like the police. It's sort of strictly executive in its function. It's chaired by a chief commissioner who's appointed for 5 years and 2 part-time commissioners, essentially. And the part-time commissioners especially normally have dual roles. So they could be Supreme Court judges or industrial relations commissioners, judges or whatever as well. Now, the Chief Commissioner, and this is why I say it's sort of a hybrid institution, is required to submit a report on the activities of the Commission to the New South Wales Parliament. So technically they report to the Parliament rather than to the Executive. However, it's designed, despite being independent of politics, to also report informally to the Premier of New South Wales, because a large number of the Code of Conduct responsibilities and the ICAC Act responsibilities say that ministers have to report not only to ICAC, but also have to mention on the front end any potential conflicts of interest to the Premier. So if ICAC finds something that a minister is doing or a government department head is doing that's potentially corrupt or unethical, they're also reporting that in a sort of informal way to the Premier as well. Now, aside from investigating, the Commission is also sort of set up to educate public authorities, officials and members of the public about corruption. And they do that quite a lot. You can see that on their website. But it should also be noted that ICAC doesn't prosecute criminal behaviour that they find. So the way that an ICAC investigation works is that they go in and they get using their very extensive powers, they investigate and they find the evidence. And then after they've found those the evidence, if they make a finding of corruption or public office malfeasance or something like that, they make a recommendation to the Director of Public Prosecutions, who is very strictly a member of the executive arm, an appointee of the executive. And those people in the DPP, essentially, the Criminal Prosecuting Agency, will then commence prosecutions if they believe that there is enough evidence for a criminal finding. They'll commence prosecutions within the court system. So if someone is essentially impeached by the ICAC for corruption, the prosecution in the courts is still a necessary process to be gone through before someone can be found criminally guilty. Now, sometimes those recommendations do result in criminal charges, sometimes they don't. So it's important to remember that just because someone's been given a recommendation by ICAC to be charged doesn't mean that the DPP necessarily will do so. And that brings me to sort of the way that this process works and some of the famous cases which that sort of runs into. So ironically enough, the first really famous case that we had for ICAC taking on a high-profile politician was in 1992. Its founder, Nick Greiner, was actually implicated in an alleged corruption scandal. Specifically, the ICAC ruled that Premier Greiner's offer of a government job to former Minister Terry Metherell was a kind of corruption. And although the charges were later dismissed by the courts, and they seem to find that ICAC didn't have any basis for this, both Nick Greiner and the Minister for Environment, Tim Moore, did resign from Parliament during that process. And it seems from there we got the precedent that whenever an ICAC investigation is commenced and you're implicated, you would resign at the very least from your ministerial position, but more likely from Parliament generally. So Greiner's government seems to set that standard. As a piece of anecdotal history, I'll also mention Tim Moore is now a justice on the Land and Environment Court. So from Minister for the Environment, he's now a justice of the Land and Environment Court, and he's a very nice man. I spent some time at the court, and he's a fantastic character. The second and probably most famous minister to be implicated, or former minister, I should say, to be implicated, was Eddie Obeid. And that one's not only the most famous investigation, in my opinion, but the most famous prosecution. Now, Eddie Obeid, obviously from Labor, was the Minister for Mineral Resources and Fisheries during the government of Bob Carr. And this was in the early 2000s. And Mr. Obeid obviously also had very large property interests, which it seems were quite extensive, not only in New South Wales, but around the place. And he had quite strong family connection ties to property development. Now, in November 2012, the ICAC began a series of investigations and hearings relating to alleged property and mining interests that he had and potential misuse of his public office in essentially obtaining benefits for his personal private interests while he was a parliamentarian specifically. Now, in July 2013, the Commission found that Obeid, as well as Ian McDonald, who was his ministerial successor, as well as a few others, had engaged in corrupt conduct in relation to their actions around the Mount Penny mining tenement and I think another one in Bylong Valley, essentially. And the position was that Obeid had engaged in corrupt conduct by entering into agreements with McDonald, whereby McDonald would act contrary to his public duty by essentially fixing the tenders and granting private licenses for mining to companies and to officials that were entwined with Obeid's personal financial interests. Now, ICAC referred Obeid and McDonald to the DPP for misconduct in public office, and the Supreme Court began the prosecution in 2015. In December 2016, Obeid was found guilty. So that was a case where the DPP prosecution began after the recommendations, and Obeid later was found guilty by the court. So this was very successful use of ICAC's resources in many people's opinions. He was sentenced to 5 years imprisonment for corrupt behaviour, essentially. And McDonald and others, they also copped very similar outcomes. Since then, however, and this is why we've had this name come up again in our news, he was charged in July 2016, for conspiracy in relation to these dealings. And that also implicated his son, Moses, I think is his name. And in October 2021, not only was he found guilty, he was sentenced to 3 years and 10 months in jail. And his son will also spend at least 3 years in jail for this conspiracy charge. Now, aside from this former Labor minister, we also have very famously Barry O'Farrell. O'Farrell in 2014 was investigated in relation to Water Infrastructure Company. Well, he wasn't specifically, it was an investigation on the Water Infrastructure Company, and he was called as a witness. Essentially, he was asked if he recalled being given a gift of a $3,000 bottle of wine. I think it was a bottle of Penfolds. And then he said he had no recollection of the gift. The ICAC the next day produced a handwritten note from O'Farrell to the person who gave him the gift, acknowledging the gift and saying thank you. And my wife loved the bottle, and we have a great time with you and your family. And essentially, it was a gotcha moment for O'Farrell. And when that was produced, he immediately announced his resignation thereafter. Ultimately, ICAC didn't end up charging him, to my knowledge. It was cleared. And there was some sort of obiter commentary from prosecutors there that said, oh, well, we didn't really want to pull him in like that. The fact that he gave an inconsistent statement, we take it as he was just not remembering that this occurred. And it seemed very genuine that he didn't remember this instance of a gift, an undeclared gift. Now, with that said, there's a couple of other cases that we should be aware of as well. In 2008, ICAC didn't just investigate ministers, they investigated Railcorp, which is a government company, and they investigated a lot of staff there and found that over $19 million had been improperly allocated. But another very important instance was when they investigated Margaret Cunneen, I should say, of the senior counsel, who was a DPP prosecutor. And they alleged that she had perverted the course of justice for one of her family members, essentially, and attempted to influence police inquiries into a car accident that occurred. Now, ICAC began its investigation in 2014 on that, and Ms. Cunneen obviously challenged that in the Supreme Court and said that they had overstepped their powers because they had essentially initiated an investigation as opposed to, without any evidence, as opposed to actually having a basis. And that was upheld, that argument, all the way to the High Court. But nonetheless, the ICAC did still make recommendations to the DPP that she be prosecuted. The DPP, obviously, because she was a former DPP prosecutor, delegated that responsibility of making the decision to the Solicitor General, who outsourced it to a interstate senior counsel. And that senior counsel said that there was not enough evidence to prosecute Ms. Cunneen. So essentially, it didn't go ahead. She wasn't prosecuted, but the recommendations were made nonetheless. And Ms. Cunneen is actually now, because of this, because of her reputation being damaged, an advocate against the ICAC on the basis that it has very draconian powers, investigatory powers, public inquiry powers that can drag someone through the mud. So, we have this very high profile case, and we have a very high profile lawyer who is actively in opposition to the way that ICAC conducts itself, essentially. Now, the reason I mentioned these examples is not only to highlight the stratification that they do investigate all different matters, but also to essentially establish that they have been called into question prior to this current ICAC investigation for the way that ICAC functions and the damage that it does in a lot of cases unjustly and without any proper basis to the reputation of particular public office holders, such as Ms. Cunneen. And from that, obviously, those are the most high profile cases, I can also say, until we had this scandal with Daryl Maguire and Gladys Berejiklian, which is obviously why we are here today to discuss ICAC.
Yeah, that's an incredible summary of ICAC's history. Thank you. But so Gladys Berejiklian and Daryl Maguire, why are they fronting ICAC?
Well, it all began with just Daryl Maguire, so far as I'm aware. In 2020, they started Operation Keppel. The investigation of him and the inquiry began. He was being investigated on allegations that from 2012 to about August 2018, as a member of the Parliament for Wagga Wagga, engaged in essentially a breach of the public trust by misusing his public office. And specifically, he implicated a number of New South Wales parliamentarians and ministers in doing so. He'd misused parliamentary resources specifically for personal, private financial gain, essentially. Now, the charges against him stem from Section 7 and Section 8 of the Independent Commission Against Corruption Act 1988. In particular, so far as I can see, there's about 5, and the difficulty is the charges are not fully articulated because they haven't made their recommendations yet to the DPP. They reopened the inquiry this year so that they could take Ms. Berejiklian's evidence or to ask her questions. But so far as I can find, from 7 and 8 of the Act, there's really 5 bases for inquiry on him. The first one is that his conduct potentially offends the clause that any official whether current or former, essentially, how do I put this? Can't act in a dishonest or partial manner in the exercise of their official functions. So they can't act in a manner that's going to give a particular interest over another interest's benefit simply on the basis of that. So there has to be impartiality. That's something which is clearly in question given his relationship with particular property developers and his relationship with particular companies. And that's something which he's admitted to as well in the ICAC. Official misconduct for breach of the trust, fraud in office, non-feasance, misfeasance, malfeasance, oppression, extortion, or imposition. Not all of those things, but that's the specific words of the legislation. Obtaining or offering secret commissions, and this is one that's the jury is very much still out on. Specifically, in relation to the Badgerys Creek property developments and in relation to some of those property developments, was he getting a commission from any of the property developers for introducing them to particular members of parliament, ministers, such as also the Premier, the sort of I'm going to take you around open door policy stuff. And then lastly, so far as I can see, the dishonesty in obtaining or assisting in obtaining or benefiting from the payment or application of public funds for private advantage or the disposition of public assets for private advantage. So basically the selling off of public resources to benefit him, or getting of government contracts or government resources to benefit him. And if I can say that the factual matrix which these fit into is specifically the Australian Clay Target Shooting Association, which is oddly named, but probably rather clear to what their purpose is. Supposedly he exerted influence through his office in his own, for his own electorate, obviously, to build the ACTS, I think is their acronym, to build a new facility for them in Wagga Wagga. And essentially, there was some question about that. Specifically, this company called G8 or Gateway, I guess you'd say, International, which had sourced furniture for the Clay Target Association from specific Chinese entities, which he has apparently got links to. And this was especially problematic because the association, through that tendering and through that process of development approval that he supposedly and allegedly had influenced, had received $5.5 million or so of public funds for its new facility in Wagga Wagga. And that would mean that if Gateway International, which was alleged to be run by him secretly, if that company was getting a private benefit from the sale of furniture to the Clay Target Shooting Association's new facility, Daryl Maguire is essentially taking money for a service that he's providing, and he's also organising the public funds. So he's getting a financial benefit from the dealings the government has with this acts, essentially. And it's also alleged that he might have exerted influence over the council approval processes for the building and for the establishment of it, which is a whole nother issue in terms of planning and development. Aside from that, he also stood to gain about $1.5 million in financial benefit relating to the sale of land around Badgerys Creek. And that's why he did lobby quite hard in relation to that project that was going on with the airport. And that's why we get some of the questions around that. And he also facilitated drop-in meetings between the property developers around Badgerys Creek and Premier Berejiklian in 2017, who at that point he was in a relationship with. So this conduct and those charges essentially pair up to be what I think will be the basis of ICAC's recommendations within probably the next 12 months to the DPP that he be charged with some kind of crime.
That was a fantastic breakdown. So on Nine News and sort of other media outlets, they aired details about Gladys and Daryl's private relationship, describing as all these juicy details before they air this actual substance of the ICAC inquiry and whether there's an attempt for pork barrelling going on. And given that neither of them have been charged yet with a crime, do you think this is the sort of reporting that should be going on during, an important corruption inquiry?
It is a good question. I think that there's a balance that needs to be struck. One of the difficulties is, the juicy details, the sex sells sort of mentality of the media has an extremely prejudicial effect upon, these public affairs, and they're quite high profile public affairs. I'm personally in favor of public justice. I don't think that it should be made private, but at the same time, I think that there needs to be a certain treatment of these matters in a very serious manner that doesn't prejudice the outcomes of these cases or politicize them. I think that the question of corruption and the question of unethical behavior or public misconduct while in office should be a question of fact, which the Commission is investigating and makes findings on, if that's its job, to refer to the DPP as a criminal matter. I don't think it needs to be sort of exacerbated or sort of turned into a celebrity issue by the media. And there's a difficult balance that needs to be struck there. How you would accomplish that, I'm not exactly sure, because you can't really restrict the media's publication of these things without completely essentially shutting down the public aspect of the inquiries. While it's public, you're going to have the media asking, silly questions and turning the story on its head, potentially to exacerbate some of the worst elements of things. So on that question, it's a hard question to answer. It's a hard policy question for the ICAC. Essentially, the only way you can really put it is that there is some reputational collateral damage to these processes. Now, Margaret Cunneen would say that there's a balance which is sorely missing here, that the ability of the media to drag someone through the dirt, or ICAC to start an investigation and the media thereby drag someone through the dirt just on the presence of that investigation, even where there's no guilt later found or there's no charges laid, is in itself a punishment without a crime being committed. And that's an argument which I take very seriously. I think that that's true. The presumption of innocence does seem to go out the window in relation to these things, particularly because the evidence is being given live and the media has direct access to it. And a lot of the time the media is jumping to the conclusions before we get any recommendations. I think the real question in this country needs to be directed to the media and the integrity of the media in how they're handling these things. I think that the public also needs to have a little bit more of a preference towards a presumption of innocence as opposed to a presumption of guilt. And that's something culturally which we need to re-imbue and we need to re-enliven, is that even politicians that are alleged of corruption should be presumed innocent until proven guilty.
In regards to ICAC's investigations, they're able to tap the phones of politicians, and it seems like they've been sort of listening in for years, and they've got no idea that they're being investigated. But I suppose that's the point of a phone tap. But then it gets broadcast, and as you've mentioned, sometimes either they do get a recommendation, but then they don't get prosecuted. Do you think that there could be some sort of reform inside of ICAC to make some of its proceedings private, or some elements of it private and other elements of it public?
Yeah, I think it is a difficult balance, like I said, especially because these are high-profile individuals that are essentially public office holders. The difficulty is there is already some provision made, and we have seen that in these proceedings, where the details have been very intimate, specific to private relationships or sexual relationships or whatever. ICAC has closed the evidence to the public and has suppressed that evidence to the public. So where it could end up essentially just causing gossip, it has closed that off to the public. But where the matters have concerned private calls or private interactions, text messages and the like, that have been specifically of a private nature, but at the same time touched on the specific issues of the case. And we can see this with the phone calls where Ms. Berejiklian was getting calls from Daryl Maguire, essentially alerting her that he was on ICAC investigation, or prior to that, calls where he was talking about specific pork barreling of his electorate and how he needed more funding for that electorate, or how he was looking to essentially benefit something in the order of $1.5 million from his property interests in Badgerys Creek. Those phone calls, and the reason they're released is not just because they're private. That's a private call without any doubt. but the conversations were released because it goes to the fact, alleged fact at least, that Miss Berejiklian was aware that Mr. Maguire was benefiting in some manner, and she had turned a blind eye, at least as it's alleged, to that course of conduct and to that potentially corrupt behaviour. And that really does go to one of the points that I raised earlier, which is, I misstated it as Section 13, it's actually Section 11. Section 11 actually provides that there is a duty for ministers and public office holders to come forward and to notify the ICAC if there is a possible corrupt conduct being committed by someone within the government. So the reason that they're playing those tapes is to, I guess, try and set out the position that Miss Berejiklian was aware that something fishy was going on and that she hadn't essentially declared that to ICAC. Alternatively, the intimate nature of some of the phone calls is to try and establish a conflict of interest that Miss Berejiklian allegedly had, because she was in a intimate personal relationship with Mr. Maguire. And that goes to the second prong of what seems to be these additional investigations around her, specifically that Section 7 of the Ministerial Code of Conduct, which is found in the 2017 ICAC regulations, Appendix A, I think it's labelled, defines that a conflict of interest includes circumstances where a decision by the Premier could potentially benefit a family member's private financial or other interests. And obviously, at Section 11 of the Code, a family member is defined as, at subsection E, any other person with whom the minister is in an intimate personal relationship. Now, that's why we've had a couple of instances of questioning from the council in the matter as to the nature of the relationship between Ms. Berejiklian and Mr. Maguire, specifically the intimacy of it. The sexual relationship Mr. Maguire spoke about, we wanted to get married, we want to have kids, I was going to retire and we were going to get married, all of that. That all came out in evidence because it goes to the second prong, which concerns Miss Berejiklian, I should say. So the reason those personal conversations and those personal phone calls was released is for a specific public purpose, because it highlights the alleged misconduct that has occurred. They're not releasing it simply because they want to put on show to the world that she was sleeping with Mr. Maguire or in a relationship with Mr. Maguire or anything like that. It was merely because there's a legal purpose for it. And to that extent, I can understand why they've done it. But at the same time, I'm also concerned that nothing could eventuate from it, which is what we've seen numerous times, where politicians have been dragged through the dirt and effectively the DPP will come back and say, no, there's no grounds for a prosecution. So the whiff of corrupt conduct essentially lingering in the air around this person with no criminality ever being affixed. But can I also say on that, just because someone is in charge, there's also the question of how the public perceives them. Bill Clinton was never indicted for any of his misconduct while in office. The Senate never convicted him of any of those offences, but the Congress did impeach him. And there's many Americans today who still believe that that conviction should have been made. The fact that the DPP as an executive office decides not to prosecute someone because there isn't enough evidence doesn't mean that the person hasn't been corrupt, just means that there's not enough evidence in the process. And that's another reason why these inquiries are public. It leaves it to the public to decide whether or not it's serious enough, in their opinion, to sort of take this person out of the game, essentially. And on that point, we've seen a number of people, high-profile people actually, in the media and in politics come out and say they think the evidence doesn't stand up against Gladys, that she's done anything serious or anything wrong. They think it's just a little bit of impropriety, personal sort of impropriety in relation to Daryl Maguire. They think that she should come out of this clean and essentially be coming back to politics. And I'm sure there's a lot of members of her local electorate who agree with that position. So, that's another thing that has to be considered here as well, is that the public opinion doesn't necessarily always swing against, but it does have a risk that the person, by being dragged through the mud, can lose their reputation. And indeed, that's something which did happen with Margaret Cunneen. She was dragged through the mud in that manner.
I suppose it's might be hard to find a balance there. So at the moment, Gladys is still the member for Willoughby. She's being assisted by at least 2 senior counsel at a cost of $10,000 a day, which is being paid by taxpayers. It's listed under the Premier's Memorandum M 2019 for legal representation of $5,000 per day per counsel. Do you think this level of spending on behalf of Gladys is acceptable for its purpose?
Yes, I do. And I'll say that because at the end of the day, as a lawyer, I can tell you senior counsel are not cheap. Senior counsel are extremely expensive to appoint. You'll find just your base level senior counsel, and I say that sort of in jest because there's no such thing. The fees will start normally at about $8,000 a day. It's one of the reasons why most people, if they're litigating anything, they won't be able to afford it. But she's actually not got the best. You'll find Brett Walker of senior counsel, this is something that's thrown around, could be charging fees in the order of something like $30,000 a day. And that's, because you're getting the best counsel in the country, essentially, if you go that way. So if Miss Berejiklian is getting special counsel, or senior counsel, I should say, $10,000 a day, that's something which I think is warranted. She has essentially very serious issues that she's facing in the ICAC. I don't suspect that she would have the funding privately to deal with that. As a member of parliament, I think it's probably within the orbit of what you'd expect, given that she's facing these things in relation to her public life, that should be covered by that. Whether or not there should be some consideration of how the finances work, let's say if she was convicted of corruption or something like that, in relation to her pensions or whatever she might have been entitled to, that might be a different question. But what's important here is that if someone as high profile as her is being investigated or prosecuted, that she have adequate access to justice. And the more high profile the case, the better the counsel that's appointed should be. So in this case, if $10,000 a day is going towards senior counsel, I think that that's a robust senior counsel being appointed. That the reality is that's the kind of defence that she needs at this point in time, and that's the kind of defence that the justice system demands for such a high-profile matter. And that cost, in my opinion, is the least of our worries as members of the public.
So the amount that's being charged to the taxpayer is actually more of a conservative amount. It's not terribly large at all.
It's not 15. I've seen senior counsel bills for much more than that. I think between 8 and 10 is probably the standard for senior counsel. So if it was a junior counsel, I would be surprised. But for a senior counsel, or potentially for multiple counsel, if she's getting multiple counsel, $10,000 isn't very much. You either have to take a problem or an issue with the fact that the public is paying for it, or take an issue that it's costing as much as it is, that the barristers are charging that much. The barristers will charge that much for basically anyone. $10,000, as I said, is fairly standard. So the only bone you can pick is that the public is picking up the bill. I'm not exactly sure why that's the problem here. I think access to justice is important. She's presumed innocent. She's a member of the public service still at this point. She's a member of parliament. If she's receiving that out of the Premier's memorandum of costs or whatever it might be, I think that's fairly reasonable. But obviously the pecuniary penalties after the fact, if she's found guilty of anything, I think they should be severe. I think the punishment if she's guilty of one of these crimes should be severe, because malfeasance or misfeasance in public office is very serious.
IBAC in Victoria is currently investigating branch stacking under the Andrews government. Is IBAC's structure any better than ICAC's at investigating corruption?
That's something I can't comment on because I'm just looking at ICAC. I haven't looked too much interstate. In terms of the branch stacking question, that's a very good question to be posed to a corruption watchdog. It's something which unspoken is an issue in basically every major political party so far as I know. But it's a very serious issue which, if it's being investigated, I would commend them for investigating that. The method that they go through to do that, I think is important though, because whenever you're investigating something which is entirely unique to one political party or one branch of a political party, you want to make sure that your investigation isn't being declared as a partisan investigation. And the processes that are being employed, therefore, need to be extremely particular and need to be seen as independent. So whatever process is there, if it's falling foul of that standard, its legitimacy is always going to be called into question.
Well, in that case, is there a model of ICAC, either state or federal, that you feel would best protect the rights of those who obviously have not been charged, while also keeping the public informed? I remember I was reading about Craig Kelly. He was mentioning he wanted a federal ICAC based, I believe, on the South Australian model. I don't really know what that is. No. Could you talk to us a bit about that?
Sure, I can't really say much about the South Australian model either, unfortunately, but I can say there have been calls for the federal ICAC to be created. The difficulty has been that looking at the history of ICAC and the record that it has. I mean, we're talking about an institution in real sense that gets something around 3,000 complaints being made about corruption, and less than 1% essentially are investigated or subject to an investigation. So this thing gets a lot of complaints. Very few matters are investigated. Since 2010 in New South Wales, at least, the focus has been on high-level corruption. So they've been trying to cut down the number of low-level corruption sort of investigations they do to focus on the high-level stuff. The difficulty that's come with the federal government, and this is what Prime Minister Morrison has said, is that it seems to tend towards a witch hunt in their opinions, and it has the potential to drag otherwise innocent people through the mud and ruin their careers. And that's very much the opinion that was taken, for example, in relation to Nick Greiner, Tim Moore, those sorts of investigations, even from early on, is that they ruin political careers and don't actually yield any results. Now, if you're on the Labor side of politics, you'd say that the reason that it's not being established by the Libs is because there's too much corruption in the Liberal Party. But the reality is, we know that this is not unique to any one political party. Corruption is across the board in politics. Wherever there is power, there will be corruption. The real issue here is a question of how does the federal parliament want to regulate those issues? Do they want to leave it to the Australian Federal Police to investigate, which is currently the model, or would they prefer to go with an independent route? And it comes down to a fundamental constitutional question, really. It comes down to the question of, do you think that the executive is capable of having its own organs and its own institutions to investigate itself, as well as the other branches of government, such as the legislative branch? Or do you believe that there needs to be some quasi fourth limb that is essentially brought on to investigate, that's answerable partly to the legislature, partly to the executive? The question in the United States, which is a model that I can speak a little bit to, was resolved with the Independent Counsel Act. If I can just confirm that. The Independent Counsel Act, which came through in the 1980s. The Independent Counsel Act essentially established that the House of Representatives of the US Congress could send an independent counsel to investigate members of the executive and members of the federal bureaucracy for corruption, and that the council would be answerable to the House of Representatives and to the specific committees of those two chambers of the House, or I should say of Congress. Now, the difficulty was we have a constitutional question there, because normally the body which tries matters is a judicial body. It's the courts. The body that brings matters to the courts is the executive. You have the police, you have investigative bodies that will bring cases. And in the US, we got the decision of Morrison versus Olson in 1988. And we got basically a court with only one dissenter. And the one dissenter was the one conservative really outstandingly on the court, which was Justice Scalia. He made the argument, which I would tend to agree with, that the Independent Counsel Act violated the separation of powers because it essentially established an investigative body that wasn't answerable to the president as the executive. The difficulty with some of these ICAC proposals is, just like the independent counsel in the US, it has the potential, in order to prevent the corruption, to be somewhere between these two branches of government. And therefore, it sort of deviates from separation of powers doctrine and the way that we conceive of power within the Australian constitutional framework. So not only do we have the difficulty in practice that it could drag people through the mud, We also have the difficulty that we're not really certain, if we establish this, where exactly it's going to sit within the constitutional framework. Certainly in New South Wales, where there isn't a strict separation of powers because there is no entrenched separation in New South Wales, it's a little bit different. But in the federal level, we do have that question. We have that question about separation of powers between the executive and the legislative, and exactly how this institution would work. So structurally, it would be a very important question as well.
We've got a question from the audience. Seeing as Gladys's legal fees are being paid by the taxpayer, do you think there should be a cap? And if so, about where would that lie?
It's a hard question. It is possible to set a cap. I just think that the cap would have to be something which would be reasonable and realistic. Whenever the members of the public hear $10,000 a day, they think, oh my God, that's incredible. She's, potentially there's weeks of work here. How much is that going to amount to? And that's a very understandable position for a member of the public to take. But that's also based on the fact, as I've just pointed out, members of the public generally don't know how much high-level legal fees are. The reality is it's very expensive. So if you did set a cap, the cap would end up being somewhere in the order of $10,000 a day if we're talking about high-level counsel. If we were talking about $30,000 or $40,000 a day, I would be getting a little bit anxious at that point, because it means that she's really got a huge legal team essentially working on it. $10,000 a day for good senior counsel, good junior counsel, and instructing solicitors, I would guess, is fairly conservative already if you factor in all of the parties which are potentially advising the Premier. So in my opinion, you could set a cap, but you would have to also be realistic about how much legal services are. The problem with caps, and I'll talk about this in another context, is that generally they don't keep up with market inflation. So for example, with legal aid, we have a lot of lawyers that won't do legal aid work because the cap on legal aid fees is essentially far less than what the market fees would be. So if you're charging normally, for example, $300 or $400 an hour as a solicitor, you won't be getting that from legal aid. There's a cap on how much you'll make. So a lot of lawyers, they just don't find it feasible to take legal aid cases. So if you put a cap, you run the risk that potentially you might end up getting a lot of lawyers turning around saying, well, why would I waste my time? I can make money elsewhere, more money elsewhere, and I can also take on cases that aren't going to label me or draw any negative attention to my law firm or to my practice. Because a lot of people associate, as we can see with some of the high-profile defamation cases with John Barilaro, they've been taken to associate the lawyers with the opinions that are being expressed by the politician or the lawsuit itself. That's not the way lawyers work. Lawyers will file the case because there's a legal point to be argued, not because they necessarily like or agree with the person who they're taking instructions from. You could have a barrister representing Ms. Berejiklian who's completely on the Labor side of politics, because the way that barristers and the way that the legal profession works is we represent the person, and with the cab rank rule, we don't really get much say in that. It doesn't matter whether they're the worst person in the country. We have an ethical obligation to represent them and to afford them proper representation within the justice system. So caps have to be very, very carefully appraised, and I would say consistently appraised, to make sure that they're keeping up with market inflation.
We've got another question. I hope you don't mind this one. Off topic, but to our current times, as a lawyer, what's your opinion on legal challenges against vaccine mandates going through the courts?
Well, that's an interesting question. It's definitely off topic, but the way that it's looking right now, we have a few challenges that have been mounted. I know definitely the Supreme Court matter that was lodged by Tony Nikolic and AFL went down basically in flames. The chief of the Common Law Division essentially didn't accept any of the arguments, and there's good legal reasons as to why he didn't accept those arguments. It's understandable why. The cases in the vaccine space seem to be quite difficult to make because you can't really find a particular right that you're directly referring to. The way that I would define these vaccine cases genuinely is more of a scattershot approach. We refer to some obscure common law resources, we refer to some international resources, and we try and assess some constitutional limits, like they implemented into their argument section 5123A, which is the provision for social security and health services in the Constitution, that power limited to the extent that you can't create a form of civil conscription. And they were making that argument in relation to the exercise of state power, which logically doesn't really line up. So at the end of the day, we're getting very, very sort of long drawn arguments. They're not as consistent as other arguments that can be made and will be made. And just like we had that one in the Supreme Court, I know we've got the John Lada case at the moment, which has drawn a lot of attention in the same Supreme Court. We also have a federal court matter that's been filed by AFL. So that's another one that's on the agenda. My priority is not so much drawn towards vaccines. I've actually just filed, I think it was 2 Fridays ago, a Supreme Court action on constitutional grounds myself, but I'm challenging the capacity of the New South Wales Public Health Act using general language to essentially prohibit protests. Essentially what we're asserting is that there is an implied freedom of political communication, as well as a handful of other common law rights, fundamental common law rights, that in order to be abridged, have to be abridged expressly. They can't be abridged through general language. And alternatively, if they have been abridged through general language, through an implication in the general language, the abridgment has to be proportionate. And the argument that we're making in the Supreme Court, or we will be making in the Supreme Court, is that the abridgment has been disproportionate in a constitutional sense, because effectively between May and about July, August of this year, one just simply couldn't protest. You couldn't organize gatherings. You couldn't even, in a number of instances, you couldn't just go outside and carry a sign. I have a number of clients that were going for exercise within their allowed area, and they were picked out simply because the police said, you're not exercising, you're protesting. Even though there's no difference between someone just going for a walk and someone, in terms of exercise, and someone going for a walk with a sign. If anything, if you're carrying a rather large sign, you're probably getting better exercise. So, protesting has been targeted. That's something which I think is a good case to run, and it has firmer constitutional grounding, and it allows more conservative legal arguments. So if we are successful, all of the questions in relation to mask mandates, vaccine mandates, limitations on how far you can generally travel, all of that sticks. The only thing that goes out the window, we hope, is the fines that have been given in relation to protesting. And even that is not certain. The reason we filed is because it's arguable, and it should be argued. And we're happy to follow it up on appeal. But in relation to the vaccine cases, I would be extremely surprised if a vaccine case gets up. The only time I can see a vaccine case potentially getting up is in the Fair Work jurisdiction in relation to employer rather than government mandated vaccine requirements. So the question of whether or not the direction is reasonable from an employer to an employee, the Fair Work Commission has already said is context-based. And in some contexts, it may not be reasonable. And that's the only space I can see a challenge being effectively accepted by a court on the vaccine grounds.
No, that's a good summary. So in relation to the ICAC investigation, phone tapping revealed that Daryl asked Gladys to, quote, throw money at Wagga, to which she agreed that she would throw lots of it. And this was in response to a by-election that caused Daryl's departure to begin with. Do you think this could be an example of pork barreling?
I think that's almost definitely an example of pork barreling. We have some different definitions of that being thrown around right now. There seems to be a general presumption by a lot of the politicians at the moment that pork barreling isn't illegal, which is why a lot of them have come out and said, well, it's just how elections work. We selectively throw money around. I think that's an open question as to whether or not, whether or not it's legal to do that and openly do that. I think if that's something which is secretly done, which I think everyone knows for a long time it has been done, I think that's a general assumption of how the political system has worked for a long time. Whether or not that is illegal, I think is a very lively question that's going to be posed in these circumstances. But one thing we certainly know is that obscuring the relationship specifically to benefit Mr. Maguire was something which falls foul of the code of conduct. So that's one thing we definitely have there. The pork barreling question is another question which is going to come up. I know John Barilaro has a lot of questions around that as well. He's been implicated on those sorts of subjects. There's a lot of politicians that have had that issue. Whether or not it's constituted as a private benefit for the benefit of that particular member, or whether or not it can be justified as a benefit for the community, because we have to remember the money is still going to the community. So you can't argue that it's completely privately beneficial. It's going to be a lively question. Now, just because pork barreling might not be completely illegal doesn't mean it's completely ethical. Throwing money at a community based upon political agendas or based upon re-election campaigns as opposed to merit, I think is probably unethical. It's a misappropriation of funds. If there's a public coffer, it should be spent in a manner of merit and needs. And there are definitely communities in New South Wales that would need the $5.5 million to build new sort of school buildings or something like that, rather than, you know, a clay shooting range. But with that said, I'm, as someone who's fiscally conservative, more concerned with the fact that $5.5 million is being spent on something which genuinely should be just privately funded. I don't know what interest the government should ever have in funding a clay target shooting association's new building. If that association exists, it should be able to provide its own funds to build a clay target shooting association. So if you wanted an answer to pork barreling, my answer would be get the government to do less. But, you know, that's far more of a pipe dream, I think, in this century.
Well, speaking about costs, another audience question: what makes legal representation so expensive? What's the restriction on the labour market supply of lawyers, if any?
Can I tell you, this is an economics question which always baffles me. It goes plainly to the Austrian School of Economics. Austrian School of Economics, the idea is that the price of something isn't determined based upon its production or upon labor or any of those things. The price of something is determined based upon perception of it. And the reality is the public put a very high value on legal services, and lawyers put a very high value on their services as well. So the answer is inflation just based upon psychology. It's you know, the reality is, I think, you know, a heart surgeon, you can say, well, saves lives, and there's probably a handful of people that can do that. In a legal sense, there is definitely some practitioners that are experts in a particular field, and only a handful could do what they do. But in a real sense, a lot of the decision making ends up in the judge's hands. Having worked in a court for a judge, I'll tell you that the majority of the time, 80% of what the judge is going to decide has already been decided after she's picked up the brief, or he's picked up the brief. The decision making is already 80% there. There's 20% of doubt that essentially the best barristers are able to work with. The fundamentals of a case are, you know, never expressed in this manner, but it's usually well decided beforehand. So it's not like heart surgery where there's some arbiter which is going to decide if the heart surgery is successful or a failure. In that circumstance, it's purely based upon how good your doctor is. So the market has a particular way of ascribing value. But in this sense, the reason for the inflation is usually lawyers who are considered to be experts by their field and who consider themselves experts are essentially able to charge whatever they want. And, you know, very, very senior counsels like Brett Walker, who are considered the best barristers in the country, can effectively charge whatever they want. It's just as simple as that.
Right. And very quickly, in your experience, what does it take to make an aspiring lawyer become a great lawyer?
Sorry, could you just repeat that a little bit louder?
What does it take to make an aspiring lawyer become a great lawyer? Another audience question.
I'm not sure I am a great lawyer in order to be. I'm not quite there yet, but the way that my trajectory is working, and the way that I've always looked at it is a great lawyer, and this is what I've been told by many great lawyers. For me as an aspiring one, is to be a generalist, to work in every field of the law, to get your feet wet in everything, and essentially to work tirelessly for your client and for the pursuit of justice. I've always taken the opinion that a generalist lawyer is someone who's in touch with the law as a whole and is able to effectively deal with any problem they come across. And those lawyers also end up making the best jurists. The best jurists, the best judges, the best academics end up being the people who can look at the law as a giant field and are able to find the linkages between the different areas. So that's one thing. The other thing I would say is resilience. Aspiring lawyers need to be extremely resilient, not dog eat dog competitive, but they need to be prepared for essentially hardship, late nights. You know, my sleeping schedule is I normally get about 3 hours of sleep a night. You work through in very, very tough conditions, essentially so that you can get to the other end and you can build a reputation. The law is all about building a reputation and building a character that people can trust. If people trust you and they trust your reputation, you will be a successful practitioner. And potentially in 40 years or so after you've started, you'll be worth $30,000 a day as well.
Well, hopefully that'll be you someday soon. Cameron Shamsabad, thank you so much for coming on. I've learned an incredible amount. Thank you so much.
It is my pleasure once again to join the Macquarie Young Liberals for this podcast, and very glad to join you again, Andrew. I'm really missing Rory, but Luke obviously has filled his shoes quite well. So thank you also, Luke.
Well, he's running for councillor for the Hills.
Oh, God bless him. All right, well, I'm hoping he's going to do well and he'll be elected. He's a worthy candidate.
I hope so as well. And thank you, Luke. Thank you for coming on. This has been the Macquarie University Liberal Club Sunday Sessions podcast. My name is Andrew Cumming. I'll see you next week.